part of what makes the parole board unique is that it is required to have a variety of different people who are on the board. There has to be at least one attorney with a background in criminal or Department of Corrections understanding. There has to be someone with a Department of Corrections background. There has to be someone with a social work background, and there has to be someone with they call her a disinterested layperson. I can assure you, our disinterested layperson is the least disinterested person I've ever met. She's very interested, and she does an excellent job. The way that the parole board works, and I don't know if any of you know this, because I didn't know it as a criminal defense attorney for the last 11 or 12 years. Panels sit 3 days a week. Those panels sit on Tuesday, Wednesday, and Thursday, and they hear cases on an individual basis. What we're tasked with is hearing both annual reviews, and that means that everyone who is in the prison system is granted an annual review so long as they're not being held on a mandatory minimum. If they're being held on a mandatory minimum and they're not eligible for release, we don't review their case. Anyone who is eligible is reviewed on, at the very minimum, an annual basis. And then they also can be reviewed by a staff-initiated review. The Department of Corrections, one of the things that they like to do is keep their prison count down, and because that costs them money and affects their budget pretty dramatically. So whenever they have somebody that they think is even remotely close to being able to be let out, they do what they call a staff-initiated review, and then that appears before us within a week or 2 weeks after that review is initiated. That's why with 8,400 prison population, we hear 12,500 cases a year, because those reviews come up sometimes every 2 or 3 months, depending on what we've asked them to do in the meantime. We have to decide if the release of the offender is in the best interests of society and in the best interests of the offender. Those are two things that are often in conflict, and those are two things that are what we struggle with on a daily basis. Most of the time, what happens is, I'm just going to be, my style is to not lay this out in a point by point basis, because in reality, that's not how this works. I'm just going to kind of tell you how things happen. We receive anywhere between 150 and 200 cases for review on any given week. We start looking at those in a specific order. Any case that has a victim associated with it, a Department of Corrections registered victim, before that offender can be released, there has to be an interview process where the victim is allowed to come and participate in the interview. Those interviews happen over video conference. The board doesn't go to the institutions anymore in an effort to conduct interviews. What happens is we set them up. Each institution has a specific day and time during the week, and if they have interviews, that's when those are held. That's either on a Tuesday, Wednesday, or Thursday. If the victims choose to come, they can sit in the audience and view and observe, and then they can make a statement if they so choose. They can't directly question the offender. They can't directly interact with the offender, but the reality is what they're talking to in most cases is to the offender, and this is how you've hurt me. This is how my life has been affected by it. And they want us to hear that as well, because it's pretty consistent. And quite honestly, the statistics demonstrate that parole boards throughout the country, if a victim shows up and doesn't want an offender to be released, oftentimes they're not released, because that has a direct effect on the people who are actually making the decision. So what happens is the board reviews any case that's been brought before it that have registered Department of Corrections victims. If those people are granted an interview, that interview then happens the following month. And when that interview happens, that's the opportunity for both the family of the offender to show up and the victim's families to show up and be present for those interviews. Once all of those cases are gone through, then any cases that don't have victims or don't have registered victims are put through. Typically, those are your drug offenses and your lower risk, your property crimes, and those cases are reviewed for whether or not we believe that the offenders can be released. It really is a balance. We consider quite a few things when we're looking at offenders. The first thing that we consider is, has the offender shown growth since incarceration? Oftentimes we're presented with a tremendous amount of information. We get to use the Iowa Criminal Offender Network, which shows us everything from the trial information to the pre-sentence investigation to any generic notes that an inmate has had while they're incarcerated, any disciplinary reports that they've had while they're incarcerated. So that means if an offender is walking through the unit and they see two people trying to move a desk and they step in and they help that person move the desk, they help lift it, that gets filed in their file as a generic note. Hey, this person was helpful. We thanked them for the help. And that actually gets considered by our board. Now, at the same time, if he walks by and tells the person working to, go screw himself, the exact same thing gets put in a generic note. It may not reach the level of a disciplinary report, but we see those, and that general attitude gets considered when we're considering their release. So when you're talking to your clients and when you're talking to them about what they need to do in an effort to prepare themselves to be paroled at the earliest possible point, you need to let them know that every single thing that they do is actually being evaluated by our board and can be seen by our board. Every time somebody writes anything up, both good or bad, that affects the way we evaluate them when the time comes to whether or not they're going to be released. The next thing that we consider is how the offender's potential releases will affect the victims of the case. The victims oftentimes are present, but also they can be societal victims. If we run across an offender who has been in time and time and time again for property offenses, then we do consider the victim society as a whole and whether or not that releasing that particular offender would affect the entire of society and whether or not it's going to be worthwhile. And then can the offender be safely released? Obviously, in cases where there's violent crimes, we have to address whether or not that person is still violent and the level of violence that we see. But there's another factor that we have to consider, and that is ultimately these inmates who are eligible for parole are going to discharge their sentences. And we have to make a determination as to whether or not they can be safely released prior to their discharge date, and whether or not having them be released and put on some sort of supervision prior to their discharge date would actually be better for them and better for society as a whole in an effort to transition them back into society. And then the level of release that they're going to have, work release or parole with intensive supervision or regular parole with required treatment, any sort of no contact orders with victims is also considered. And then the next thing, the other part of that balance is how the release will affect the offender. There are, quite frankly, some offenders that are not ready to go back into society. The ones that are most obvious are the juvenile life offenders. Obviously, that's been a big thing that's been in the news, and you can't just take someone who was arrested and incarcerated at age 16 or 17 and release them back into society after they've been incarcerated for 25 or 35 years and expect everything to just be okay. So oftentimes what my predecessor initiated in working in conjunction with the Department of Corrections is a secondary process for releasing certain offenders where you take them from a maximum security institution, drop them down into a medium security institution, and then into a minimum security institution, and then into a process where they actually have outs into the community, where the Department of Corrections will take them to a grocery store so they can see what the scanners look like. They take them to a cell phone store because they've never seen or dealt with a cell phone before. They help them obtain a debit card. They help them obtain bank accounts and slowly release them into society. the offender may have shown all the skills that are required to be released, but it still may not be in their best interest to be immediately paroled, regardless of the situation. It's oftentimes better for them to go through a process so that they don't end up back where we are. And then would supervision upon release benefit the offender? That's a little bit about what I was talking about with the whether or not it's better to release them prior to discharge, or whether or not it's better to just allow them to discharge their sentence and run free. The information that I've gotten from the Department of Corrections is if they're going to be paroled, they want about 6 months to work with them. So they want them to be released a minimum of about 6 months prior to their discharge date so that they can have that time to acclimate them back into society. And then, has the offender prepared themselves to reenter society? They, that's just a general attitude that an offender has to have. And the only way that you can determine that is by the notes and by interactions with the offenders. You have to kind of be able to get a feel for whether or not this person has changed their attitude, or whether or not they're just going to go right back to what it was they were doing before. Just a few statistics. This is the general numbers. It was about 2,500 cases that we ended up reviewing in fiscal year 2017, and we'll probably be about on par with that. Out of those cases, roughly a third to 40% of them end up being a flat-out denial. The remainder of them, by the time they get to us, appear to be in some way moving towards release. The special sentence, obviously you guys are familiar with sex offender crimes. Special sentences are granted following the discharge of the initial sentence. So they can't be placed on a special sentence until after they discharge their sentence. Even if they're granted an early parole prior to discharge, they still come back and end up on a special sentence parole after that. The parole revocations, I'll let Mr. Clarke get to when we get to those numbers. There is a table that I have. I believe it's in your packets, and this is one that I really wish I would have had easier access when I was practicing. And it's the average number of months that are served by people convicted of certain crimes. Obviously, this is just an average. Obviously, the numbers are affected by the way the inmate acts inside of the institution and the way and the risk assessments that are associated with them. But this is a pretty fair guideline for how quickly someone is going to be, at the very least, placed in front of us and how quickly they're going to be considered for parole. And the other thing that I think people don't know, and you guys probably will get calls on, are after your client is paroled, they don't just open the door and let them go. There's a certain amount of time that they have to take to process out. That's the other slide that I gave you. That's the median number of days from the time that someone is actually paroled until the time they're actually released. What happens is after they're paroled, where they are being paroled to, it depends on the individual district in which they're being paroled to. They have to have time to process through that and go through the process of making sure their parole plan is put into place, making sure the place they're going to go to is put into place, and making sure if they're going directly to a treatment facility that that's available at the time. And then there's out-of-state paroles, which also affects the total number of days that it takes to get out. And then once they get out, as long as they're doing well, they'll never have to meet Mr. Clarke. But if they're not doing well, then they go through a revocation process.
All right. So since most of my hearings are by phone, many of you may have appeared before me and I don't know it. So I know at least one gentleman here I've seen before. In some ways, parole revocation hearings are just like probation hearings. In some ways, they're very different. So I'm sure all of you have all done probation, it's the same standard. Our hearings, though, are done almost entirely in jails. They're done over the phone. If the offender wants personal appearance, that's going to be by video conferencing, ICN, Skype, that sort of thing. So that's how we're able to do, I think the number earlier is about 3,000 hearings we're expecting this year, about 2,400, 2,500 the last couple of years. And just because they're having a revocation hearing, as a defense attorney, I always hated that term, the probation revocation hearing, because that was shouldn't be revoked. And just because we have a revocation hearing doesn't mean they're going to get revoked. That's one reason why our hearings are perhaps higher, trying to do a lot more in the community, especially those with drug violations, trying to get them treatment. It's their benefit, society's benefit to probably get that treatment done in the community, and it can take a while. But the first thing you need to do is you need to get yourself appointed, and that can be tough. One thing we've been working on this last year is making sure that judges and magistrates realize that parolees do have the right to apply for court-appointed attorney. Would occasionally get orders from judges saying that the parole board will handle that, and we don't. The court-appointed attorney or the bond is all handled by the district court, and then we handle everything else. So if there's a bond, what the amount of that bond, whether there's a bond review, that's all going to be done by a judge, by a real judge. And then I get to do the other part.
His words, not mine.
Yep. And then if you do get appointed, make sure you have the right appointment order. Because in order to be appointed for a parolee, there's a little different standard than just a criminal defendant. So not only do they have to be indigent, but they also have to show that they lack the skill or education to properly defend themselves. And they have to show there's a colorable claim. Now, many of them will have a colorful claim, but whether or not it's colorable, the judge decides at the initial appearance in a matter of minutes. So I'm not sure how that's always done, but some counties, attorneys are appointed routinely. Some counties, they're denied routinely, and that all varies. The amount of the bond in 5th District, it's almost always going to be a no bond hold. And some districts, surprisingly in Blackhawk County, maybe a smaller bond, and people bond out while they're waiting for their parole revocation hearing. Sometimes multiple times. But once again, we don't control the bond part. Due process, they have a liberty interest in their parole freedom. So unlike a hearing in the prison itself, where there's no attorney, here there is that option to apply for attorney. They can always hire an attorney. Day reporting, some work release facilities will do a day reporting status where they're still technically a work releasee, but they're living at home. And as soon as they leave the facility, they're treated like a parolee. So even though they're on technically work release, once they start living at home, if they violate, they have an ALJ hearing, not like a work releasee that's going to be more, or even more administrative, and no ALJ making that determination whether or not they get transferred back to prison. Just like a probation hearing, parole hearing has 2 stages: the adjudication, did a violation occur, and then what now? Most of these, the main issue is on disposition, what now? Most of these violations considered quote unquote technical, they're missing appointments, dropping dirty, not going to treatment. Those are usually pretty easy to prove up, though it's the exact same thing as a new criminal charge. It's the exact same standard. Everything else, whether it's a new criminal charge or missing an appointment, in reality, it's the same sort of standard to prove that up. But the PO is easy enough to say he wasn't here at 2 o'clock on the 12th like he was supposed to be. Disposition, because that's the main issue. That's if you get appointed to a case, which many of you won't, you need to focus on that. Come with a concrete plan. What is it that you want to do? And even before we get to that point, one thing to understand is if you get appointed, you need to communicate with the PO right away. These things move fast. You've received your appointment order through EDMS, and that's probably the last thing you're going to get from EDMS. Because we're not tied in. If a hearing is scheduled, it's going to come from the PO. You're going to get that notice via email. Whenever I talk to POs, I always harp on them. Contact, call, email the attorney right away. Go on Courts Online, find out who was appointed, get a hold of them. So now that I'm talking to you folks, get a hold of the PO. You'll find out from the complaint who filed it, so then you know who to contact. They're only entitled to 7 days notice prior to their hearing. And DOC policies, if they're in custody, to have a hearing within 14 days. So don't just wait for, you never got an EMS notice telling you about a hearing, so you got to get moving quickly. Check out the admin rules. We did an update to our rules this last fall, a little more user-friendly, a lot more information there about exactly how to proceed. If you have requests for a continuance, you want to make certain motions, we can do that. It doesn't have to be formal, just need to get the communication out to the PO and to, there's 2 ALJs, myself and Michelle Becker, both based here in Des Moines. But the hearing itself, everything's under oath. And we can reinstate them, we can continue them on parole, we can send them to work release, or we can send them back to the institution. And obviously, each one's different depending on the severity of the new allegations, what their underlying offense is there a connection to it? You know, people that are on for a lot of violent offenses and get into an assault at a bar, well, they shouldn't be at the bar, number one. And number two, the assault kind of really plays into, they haven't really learned some of the stuff that Jeff was talking about, or they're ready to make a change in the community, they're not. So maybe time for them to get another timeout. Yeah.
I seem to remember some case law, maybe it's a mistake about you can't send them to a residential treatment facility for substance abuse. Is that a correct recollection?
Question was about whether or not we can send them to the residential treatment facility for substance abuse, being like the work releasee, or just a private inpatient treatment?
I seem to remember some case law like that about that you can't send them to any sort of residential treatment. But maybe that's a mistake.
If they come through the ALJ, we can order them to the residential facility, the work release facility, either as a condition of their parole, so they're still a parolee, but they're required to reside there. We can send them to work release, where they're just a work releasee, they got to stay there. If it's a residential treatment and they have evaluation that says that they're recommended for inpatient treatment, we can order that they do inpatient treatment. And if they don't do it, they're violating their parole condition. I mean, obviously we can't order Prelude to take them, but we can order that they do some inpatient, and if they can get in a place, great. Not sure that answered it.
Maybe I was thinking of it where the district court probation. Maybe I confused it.
And if they are ordered somewhere specifically, then they're likely to get, then they're going to get credit for that at the end if they get revoked. So maybe that's a different issue too. Some of the issues with probation versus parole is, as a parolee, they're getting credit towards their sentence for every single day. As a probation, they don't have any credit unless they're actually in custody. So as I said earlier, the hearings are almost always in the jail unless it's the 5th district. All the males are being housed at Newton Correctional Facility. The women are housed at Mitchellville. And so our hearings are being held out of there. We have some hearings at Oakdale, out of Johnson County. Not every single one. Some are still being held in Johnson County Jail, but some are transferred up to Oakdale. I think it's more the sex offenders because they may not have facilities available in Johnson County. It's a very small jail. And then since these happen fast, there may be, you got appointed, hearing got scheduled, and of course, you guys have busy schedules, and you have trials, you got other hearings and other proceedings you got to take care of, and you need a continuance. The PO is probably not being very agreeable, like, no, we got to have a hearing. That's when, you know, you can email the Board of Parole, just CC the PO and say, this is why I need a continuance. You know, the PO's schedule, it all runs through them. So sometimes they're not always flexible and trying to move things around. And partly it's because they're getting hammered, don't move things around, get them done quickly. So, but just move on up the chain and ask. And if there's a legitimate reason, then it'll get moved. I mean, obviously, everybody's got schedules they got to deal with. Don't look for like 2 months down the road. But, you know, sure, we can go a week, we can get another day to try to get something set up, or you have a bunch of witnesses you want, let's get into that. They have a right to cross-examine witnesses. You have a right, or they have a right to have witnesses called on their own behalf. It gets kind of complicated because these are in the jails. Some of these are in prisons. The 3,000 hearings we're going to have this year, probably about a fourth of those, over 700 hearings are going to be at Newton. So that's even more difficult. So we're not having witnesses go to the prisons. Sometimes the witnesses aren't going to the jails. That depends on the local jailer. So then they're also on the phone calling in so we can get information. Everybody's put under oath. Had one yesterday. We used the conference room at the jail up in Sioux City because the jail didn't want them there, but some of the counties have the law enforcement centers a little more involved. And so they were able to have everybody in there, had a parade of witnesses come on in, testify on the person's behalf. One thing I found interesting with regard to Fifth Amendment issues is there may be a whole slew of violations or allegations. Missing appointments, dropping dirty, but then there's also the new criminal charge. Well, they can testify about missing appointments. They can testify about, you know, why they dropped dirty or other sort of stuff, or why they lost their job, and then not talk about the new criminal charge. So that's totally fine. But if they open the door, then it's fair game. So, but if you're counseling them, you know, you can just deal with, for your direct, what you want to talk about, and then anything not within the scope of that direct isn't brought up at all. We do have power to subpoena witnesses if you need it. Once again, everything's got to go through the PO because our system, ICON, the computer system, stuff has to be inputted in there. So talk to them. They'll process the subpoena. They may give a little bit of pushback, in which case, once again, contact the board. Judge Becker, I can take a look at that, decide whether or not they're relevant. Because one thing, since we're dealing with some of the jails, if you have 10 character witnesses, we may not need all 10 to be parading through the jail. So pick and choose your best ones, affidavits, letters of support for everybody else. We will read everything that is submitted on your client's behalf. One of the big issues is with the pending charges. Have to tell the POs that it's not the arrest. The arrest is not the violation. Have to tell parolees and defense attorneys it's not the conviction that's the violation. It's did they commit the offense? And we don't have to wait for the criminal charge to be done first. We can go forward, we can go at the same time, we can delay. It depends on the nature of the new charge. The more complicated the new charge, there may be more likelihood to continue our hearing and let that take precedence. But once again, don't have to, and the PO, yeah.
So the person gets arrested, you're out on bond. You want to revoke. That's your decision. They have to get another bond, or bond means nothing. Kind of give me a little, I mean, I obviously haven't done a lot of these. I'm always mystified. But I'm just asking, what happens with the fact that they're bonded out? They're not having any special pretrial limitations. What do you do in the face of that with your decision? And let's assume you say, we're going to revoke, and I want you back in prison. So what happens then?
Well, and this comes up sometimes. I explain it's just like you have a charge out of Polk County and a charge out of Dallas County. You may have bonded out of Dallas County, pick up a new charge in Polk, and Polk sends you to prison. It's the same thing as you got your new criminal charge, and then you got a parole hold as well. You may have bonds on both of them. You may have bonded out in the new charge, and you're just being held on the parole hold. In some counties where they allow them to bond out of both. If my order is to go to prison, then they're going to go to prison, and they need to contact that defense attorney right away to figure out how to resolve that end of it. If they're being held on the new new charge as well, then they're going to stay in the jail until that's resolved.
There's no bond on appeal from you.
Correct. Right. So, and we had one recently where that happened. He posted his appeal bond in his aggravated misdemeanor. He got revoked, and he was trying to figure out why he was still there because there's no appeal bond in the parole matter. So I think he was able to get that money back. I don't know. It's not my. Yeah.
I represent this guy who is on parole, facing a Class B, new charge. He's taken back to Newton. Now he's back in county jail. I don't understand what's happening here. Can you explain that? He's still on parole.
If he's still on parole, why he's at the county jail, I'm not sure, unless he was, sometimes what will happen on those is I had one where the district court wanted him to go to Bridges for inpatient treatment. And so he's going to wait in jail until he goes to Bridges. Then he comes to Newton, we're going to have the parole hold, the parole hearing, and once we're done with him, we'll send him back to Polk County Jail so he can deal with the probation issue. But they don't usually go back and forth.
Both not everybody knows happening. So he just reappeared in county jail and brought back. Newton. I'm just curious. I don't know.
Was he in Marion County, by the way?
Marion County, started Marion County.
We can talk afterwards, I know that one. So I'm why he's back there. Yeah.
Let's assume you want to appeal, you can just petition judicial review.
You do an appeal to the board, first of all,
First to the board.
and then if that's unsuccessful, to PCR. Parole and probation revocations are PCR matters. If they're denied parole from the institution, that's a judicial review, I believe.
Yes.
So make sure, yeah.
Yep.
Get the right one.
Yeah, parole, if it's parole, it goes to the board. If they're denied parole, they appeal to the board again. That's heard by other board members, not the board members who sat on the panel. And then after that, then it's judicial review.
Yeah.
I have a quick question. I'll try to speak loud enough so that the folks that are on the webinar can hear. I have a practice in Minnesota and Iowa, and so oftentimes I'll have a client that you can foresee commits a crime in Iowa, goes up into Minnesota, commits a crime, charged in both jurisdictions, and to make it easy global resolution of the matter, we'll settle both cases, run concurrent to one. Now in Minnesota, when they get sent to prison, it's not like Iowa. They don't have an indeterminate sentence. You know when they're going to be out, when they're sentenced, right? So because of that, sometimes we'll do a Minnesota sentence and then have the Iowa sentence run concurrent to it, okay? The way I understand the statute is that the time in Iowa doesn't start running until the inmate is received into Oakdale by the Department of Corrections. But if they're sentenced in Minnesota after they're sentenced in Iowa and get sent to Stillwater or whatever prison system in Minnesota, have already been sentenced in Iowa, they don't actually ever go to Oakdale, right? Because they're going to go straight to Minnesota, whatever jurisdiction sent to the prison system in Minnesota. But we have an agreement that it runs concurrent. So the question is, does the time start running at the time of the sentencing order, right? Or the minute it's issuing, right? Or does it start actually running so they get credit when they have to be checked into Oakdale? Do you understand my question?
I think the way that would work is that they would get, effectively what they're going to get is they're going to get jail credit. And then I'm not 100% positive because like I said, I've been on this job for less than 2 months. So typically I believe what would happen in that type of a case is they would go to Minnesota, but they're still on an Iowa hold as well. So they would get credit for that time that they're in Minnesota, so long as that's part of the sentencing order in Iowa. Then at the end of their sentence in Minnesota, they would still have to come back to Iowa and process. And it's possible, depending on how long they had been in the Minnesota prison, they would be granted their time. And then that would either probably be a staff initiated to us for parole, or it's possible they may have already discharged their sentence, depending on what their sentence in Iowa was.
Sure, but the theory being that the time that they stayed in Minnesota, even if they hadn't checked in prior to hand at Oakdale, they're still going to get day for a day credit for the time they spent in Minnesota. There may be leftovers because the overlap may not be exact.
I think in the same way that if they were staying in a county jail. And it's going to largely depend on how the order is written in Iowa.
Right.
So you need to make sure, that's one of the things that we've come across, and I believe Steve was going to address that, about jail credit on revocations. And if they pick up a new charge and you agree with the county attorney that they're going to be, the sentences are going to run concurrent. Whatever's going to happen is going to run concurrent. That has to be placed in the order. By matter of law, they run consecutive unless it's stated in the sentencing order that they do run concurrent. So it's not like you normally think, where normally everything just runs concurrently unless it's stated otherwise. When it comes to parole revocations, it's actually the opposite.
I can tell you regarding the out-of-state, because we'll have automatic revocations for an out-of-state conviction. If they're in-state, we use the time they arrived at Oakdale or Mitchellville. But out-of-state, we use the date of the conviction itself. So it sounds like they're getting credit as of that date. One thing about parole and probation is there's no exclusionary rule. Probably, maybe. As of now, there's not, and that's been the case. But a year ago, December in 2016, State v. Brooks didn't actually say there was an exclusionary rule, but the court went to the merits of the motion to suppress for probation case, rather than saying, no, you don't get 1 year. So that's could be telling. Of course, Klein back in 2000, I was an idealistic young public defender when that came out, and I thought this changes everything. And it's been 18 years. So it makes my life a whole lot easier, but whether or not that's going to be the case, I don't know. So if you get a case that maybe was something you want to look at for your PCR, because obviously I had somebody argue that to me, that I should exclude stuff. It's like, well, I don't have that authority. So, and they were using Brooks. I'm like, that was when the Court of Appeals said that the Court of Appeals was going to rest on the Supreme Court's decision. And then they were asking me to overturn the Supreme Court. I'm like, that's not going to happen. So, all right. Just if you need to make a motion, you're requesting subpoenas, witnesses, continuance, email sufficient, just include the PO, and you can contact us and we can try to get stuff done. Don't file things in EDMS. Get that oftentimes from attorneys. Hey, did you get the stuff I filed? Nope. So the PO has to upload it into ICON, which is our communication system. So just get it to him or her and they'll get it to me so I can review it. Okay, on the automatic revocation, and this is something, even if you don't do a single parole hearing, this is something as a criminal defense attorney you got to understand. Jeff kind of touched on it, but even more so. If somebody gets a felony or an ag prison sentence while on parole, their parole is automatically revoked, which is just the first half of it. The second half is they will lose time on their sentence for every day that they're out of custody, from the date of the offense until the date of the conviction or the reception at Oakdale or IMCC, ICIW. So most time they're sitting in custody, so that doesn't play into it. But if you're somewhere where they're on probation, they're on parole, they pick up a new charge, the district court gives them probation again, we don't revoke them since they were given probation. We'll say, okay, we'll give you another shot too. And then eventually that probation is revoked while still on parole. All that time is lost by operation of law. There's no discretion. At a regular hearing, I have the discretion to decide whether or not to take any time, but at that, there is no discretion. Yeah.
Is there an exclusion for the aggravated misdemeanor? What if that's, say, a simple possession? The only reason it's an aggravated is because of fire.
If it's an aggravated or a felony and there's a prison sentence, not probation, but they're incarcerated to prison, then that's an automatic revocation.
What about the fact that it's an aggravated based on two prior convictions?
If it's an aggravated, it's an aggravated. So if they're on drug court, we had this, I think last summer, somebody was on drug court for 16 months. And during the course of his drug court, all that's on parole, he ended up having that probation to revoke that he was on drug court for. He lost all 16 months. There's nothing anybody could do about it by operation of law. So if you have these people, make sure they understand that. If his parole had been revoked prior to the probation, he wouldn't have lost those 16 months. So if you have somebody who's also on parole, look into that, because sometimes I'll have attorneys that want things scheduled quickly because they want to get the parole taken care of first, because they understand that that's a big benefit to their client. So if nothing else, come away with that. And when that time is lost, that's day for day. There's no 1.2 and all that kind of earn time. It's a day for day sort of time loss, which is different than POs don't understand that as well. Oftentimes they keep thinking things get cut in half, and when they lose that dead time from an automatic revocation or ALJ takes it at a hearing, it's a day for day. Any other questions?
For the purpose of appointment of counsel, what do you consider a culpable?
I don't make that determination.
What do you think is realistic?
I don't really know, because I'm not sure that is really looked at very carefully. Because some of these where they just automatically say no. I think oftentimes they're just looking especially at the adjudication phase of it. You know, somebody who absconded for 6 months, the judge may decide, no, you don't get one, because how are you going to fight the fact that you weren't around? Even though there may be some other issues to it.
The statute says, I think, that culpable claim for disposition as well, correct?
Oh, I think so, yeah. But I'm not sure if that is really being looked at by the magistrates and district judges.
I'm a magistrate, so that's why I'm asking.
Oh, okay. Well then,
Something like that.
okay.
Generally, for new crimes, I don't, again, I think that's unconstitutional. But nobody brought that to me, and like you, I can't overrule the Supreme Court and the legislature. But again, new crimes are narrowly going to point for, but things like out of place of assignment, dirty UAs, maybe. So I was just curious of what you thought of that.
Well, the one thing for the new crimes that may be something to consider is depending on the level of the new crime. Because obviously, not obviously, because if it's a misdemeanor, new crime, they may not get revoked. So that may be something to think about. And there may be even more need to have somebody represent them in that case, especially given some of the intricacies regarding automatic revocations and that sort of thing. Trying to explain that difference to some of these folks doesn't really help. So if I got an attorney on the other side to explain why they may want to voluntarily be revoked, sometimes that's helpful in the long run for them. Yeah.
How does the board determine who is a victim for purposes of victim notification and participation in parole proceedings? If there is a plea agreement that involves multiple charges, some of which are dismissed and some of which are pled to, but different victims between the charges that are dismissed versus those that are pled to.
I guess,
Say you have 2 thefts, you have a global plea deal, one theft with one victim is dismissed, the other theft is pled to. Who's a victim for purposes of parole?
largely what happens in a case like that is that the county attorney's office is already working with the victims. So once they're working with those victims, they explain to them after a case is completed, if an individual is going to end up in prison, then they give them the forms that they fill out in order to become a registered Department of Corrections victim. Once they're a registered Department of Corrections victim with us, they're considered a victim on the case. Once that happens, then they have the right to have notice of all the hearings. It's 20 days notice that they have. That's why the interviews occur about a month after, because the victims have a right to have 20 days notice prior to an interview being conducted so that they can be present, or through the network, they can also be present at one of the other institutions if that's easier for them to get to. But largely that comes from the county attorneys and from the counties themselves, and they come to us and register as a victim on the case. I haven't had a situation in my time there where I've had any of the staff come up to me and say, you know, this person isn't really a victim on this case. So I haven't had that come up. I don't believe it's an issue. I believe that as long as they're a victim on the case and they register, they're considered a victim. That can be family members, and it can be the actual victims of the case.
But the key is that they're registered. We have had that issue where somebody complained who was a victim of the case that they weren't notified, is because they didn't talk to their local county attorney, because under Chapter 915, that's how they get registered, or the county attorney failed to process the paperwork and give it to DOC or us, so the person was not registered, so they didn't get notification. So that's the key part right there, is make sure they're registered. And that's through the county attorney's office.
And sometimes victims come and speak on behalf of the offenders. And it doesn't even necessarily mean that there has to be a relationship over time. Sometimes they just feel that this person has fulfilled their debt and they want them to be released. It happens. It's not strictly the domestic cases that I'm sure we're used to dealing with in the criminal law area, where the victim wants to come advocate for her boyfriend. But oftentimes it's other victims who still want to say, you know what, enough, let's move on.
I have two questions relating to the use of your chart that you've provided. The first question is, how do you use this chart to assess someone who has crimes that may be of a different nature? For instance, they have a Class D drug crime, and then they also have a Class C willful injury. How would you combine those sentences using this chart, if there even is a way to do that?
Are you talking from the criminal defense standpoint or from our standpoint?
From the standpoint of, if you would use this chart to not specifically advise a client, but say people like you who would plead to a Class C willful injury and maybe a Class D drug crime and get a 15-year sentence, would maybe do this amount of time based on the chart. Not specifically telling them, but giving them this chart and using it as a predictive tool.
I would advise you to know that we don't use this chart. This chart, from the parole board perspective, we never look at this chart ever until it's time to file our annual report and we're putting the numbers together. That's just what it actually is. We don't look at this and say, well, you know, the average person that committed this crime gets out about now, so this person gets out about now. That's not how we look at it at all. So if you're talking about advising your client based on what others have done, I would be very careful about making sure that they understand that this is what has happened average, and this is what has happened on average from prior boards. We have myself as a new board member, and we have another new board member that was just appointed by the governor a week ago Friday. So the makeup of the board changes, and it's a fluid thing. And even on individual panel days, the makeup of the board changes. So if you're looking to give somebody an idea of how much time they're going to spend, this is maybe something you would want to consider. But I would make very sure that they know that this is just a general idea of what has happened in the past. And if they're a jerk to everyone in the jail when they're there, these numbers are not going to apply to them.
Sure. And the second question I have on this chart is, I note for felonies enhanced penalties, there's only one category of other criminal offenses, but there's nowhere in here that deals with any kind of habitual offender enhancements. Is that just not separate data that's categorized?
I think, yeah, I think there was a footnote, and I apologize that I didn't put the footnote in there, that the other criminal category that you see on there is largely habitual offender violations.
Anything else?
You have something?
That's it. Thank you, gentlemen, for joining us.